Hello, everyone. And first of all, I want to thank the folks that had emailed me after my last video. I really appreciate the feedback, the comments, and the respect that was shown in the emails that were sent to me. In this particular video, I want to chat with you about why, in my opinion, the Baker Act is far worse than if you were arrested. So let's talk about initially about what happens typically when you're arrested. So unless it's a sort of a minor crime where the police might issue you what's known as a notice to appear, which is basically a document which tells you when to go to court. Typically in a criminal case, someone's going to be arrested. So I'm sure you've all seen TV and watched sort of, what is described as the perp walk, right? The person is handcuffed, their hands are behind their back, and they're placed in a police car. Now, typically what happens after that is they're taken down to the local county jail and they're booked in. And that's a matter of public record. You can go online, you can look up the sheriff's office booking blotter, you can see the photo of the person, the booking photograph, the mugshot, and you can read all about what they're arrested for. And it'll tell you about the bond information. Now, if they don't bond out, the next morning they're going to see a judge. And at that hearing, they have a right to counsel. If they can't afford a lawyer, the court's going to appoint one for them. The court is going to tell the individual as to their rights to counsel, their rights to remain silent, and things of that nature. So they get fully informed as to what's going on. If the case proceeds beyond that and someone is officially charged by the state, normally the case is going to get reviewed by the state attorney's office, that prosecution is, again, a matter of public record. You can go onto the clerk's website, you can read the probable cause affidavit, you can see the name of the judge, the name of the lawyer, the name of the prosecutor. All these things are a matter of public record, right? Nothing is hidden. If there are hearings in the case, and again, the clerk's website will indicate when those hearings are going to take place, you can attend. You can go as a member of the public, somebody who has nothing to do with the case, you can go and you can attend those hearings, you can attend the trial. It's all a matter of public record. However, when somebody gets Baker Acted, things are very, very different. So in a typical situation, if the police are called to a scene, so for instance, you have to call 911. You're afraid for the safety of a loved one. Typically, the paramedics will get called, the police will show up, and if a Baker Act is initiated, one of two things are going to happen. So if your loved one needs to be taken to the hospital, they're going to be placed on a gurney and placed in an ambulance. Frequently what I see, and I hear from the families that I work with, is that their loved one is literally strapped to the gurney. Wrists are strapped to the gurney, feet are strapped to the gurney. They're taken to a hospital, and they are taken to the emergency room. They're medically cleared, and then they are transferred to another facility in most cases. Now let's say that there is no necessity for the person to be taken to the hospital. Then the police are going to initiate the Baker Act at the scene. The person is going to be handcuffed, their hands will be behind their back, and they're going to be placed in the back of a patrol car, just as if they were being arrested for a criminal case, okay? No probable cause, no one has committed a crime, and yet they're being handcuffed and they're being placed in a patrol car. So in the instance where the person is taken to the hospital, once they've been medically cleared, they're going to be transferred to another facility. Now, I can tell you from one family that I spoke to, their loved one was taken to the hospital, and then they were transferred, and then their loved one basically just disappeared. They couldn't get any information. They had no idea where their loved one was. No one would talk to them, and it was as if they just sort of fell into a black hole. So that can happen. So in the instance where the person is taken to the receiving facility as opposed to the hospital, they're transported by the police. They will be taken to this facility. The whole proceeding is confidential. It's basically done in secrecy. You can't go to the clerk's website and look it up. You can't look at the booking blotter on the sheriff's website. This whole thing is basically being done without anybody knowing what's going on. So if you're a family member and you call the facility, if you even know where they are, they're probably not going to talk to you. When your loved one is at the facility, no one is going to tell them that they have the right to speak to a lawyer. They're probably going to be told that that the facility can hold them for up to 72 hours, which is true, with a caveat, which I'll talk about in a second. If the 72 hours expires over the weekend, guess what? The weekend doesn't count. So if you get Baker Acted, say on a Thursday, you're going to be there at the facility Thursday, Friday, Saturday, Sunday, and then on Monday, one of two things are going to happen. Either they're going to ask you to sign some type of voluntary admission documentation, which gives them another 24 hours to hold you, and another 24 hours to run to court to ask a judge to involuntarily commit you. And you're basically going to be held against your will, okay? You're going to be deprived of your right to be free, okay? There's been no hearing. You haven't had a chance to speak to a lawyer. There's no judge, and it's all done in secrecy. So what I want folks to understand is that when you get Baker Acted, it's really serious stuff, and that 72-hour window is not necessarily a 72-hour window for them to hold you. It's a 72-hour window where you can enforce your rights and run to court, because after that, the clock is ticking. And if the facility gets to court before you, you're going to be playing defense. And then the facility is going to ask a judge for the state to step in and make decisions for your loved one. So when you think about a criminal case, right, if you've ever walked into a courtroom or you've seen things on TV, you have a prosecutor there, you have a defense attorney, and you have a judge. And you may or may not have a jury, okay? That's a criminal case, and anybody can go and see it. But at a Baker Act hearing, one that's been initiated by the facility, again, there's a prosecutor there, there's a defense lawyer there, and there's a judge. But nobody can go and see the hearing. It's done in complete secrecy. There's no record of it. You can't go and look on the clerk's website and find any information about it. So understand the serious nature of the Baker Act and why it is absolutely critical in the first 72 hours for you to get to court and ask a judge to either discharge your loved one or at least enable you to do a bed-to-bed transfer where your loved one can be taken to a facility that you choose, so you get to make the determination as to how they receive medical attention and how they receive services for any mental health issues. So I hope that clarifies things, and I hope that you understand the serious nature of the Baker Act. With that said, I love the comments that I get. I like the emails that I get. Feel free to reach out to me. If you have any questions, you're welcome to call me. The office number is 561-419-6095. You can email me, mark@drugandalcoholattorneys.com. And thank you once again for all the feedback and attention and comments and help that everybody gives us. Thank you.